Okay, are we still waiting for anyone on your side for Todd Weiler or? Oh, he's hidden away there, unpacking. Mr. Alexandrov, over to you.
Thank you, Mr. President.
Mr. President, members of the tribunal, we're passing out, or I guess have passed out, binders that include the slides that are part of the presentation. Included with that on the left-hand side, you'll see are translations of 3 documents that we'll be talking about in the opening, and they are exhibits on the record, but these portions of those exhibits were not translated, and pursuant to the tribunal's letter of March 5th, 2015, that we are providing those translations for you at this time.
I ask, have these been provided previously to claimants?
They actually discussed those same stamps in their opening, so we believe that there should not be any controversy.
No, have you had a chance to had a look at that?
I think just go ahead. If we have any concerns, we'll raise them.
Okay.
Mr. President, members of the tribunal, this is a case about individuals and real estate developers who purchased land in Costa Rica that was part of a national park, the Las Baulas National Park, created to protect the nesting habitat of the leatherback sea turtle, which is a critically endangered species. Claimants purchased their land knowing that it was located in the park and therefore subject to being expropriated, but they hoped that either the government would never get around to expropriating their property, or that it would amend its laws to allow claimants to develop their land. But claimants' gamble did not pay off. Instead, the government began the process of expropriating properties located inside the park, including claimants' properties, and offering fair market value for the land inside the park. Rather than allowing the Costa Rican government's expropriation procedures to run their course, claimants chose to seek millions from Costa Rica under the Dominican Republic, Central America, United States Free Trade Agreement, which I shall refer to as CAFTA. To maximize their damages claims, claimants seek to recover more in damages that they themselves were willing to pay when they purchased the land knowing that it was inside the park. They now assert that they did not know the land they purchased was in the park, and therefore, they say they are entitled to the value of their land as if it were outside of the park. The truth is, the land claimants purchased is part of the park and has been part of the park since at least 1991. And claimants were fully aware of that fact. And they're simply, therefore, not entitled to the windfall they now seek. If you turn to slide 1, these are the 3 topics we'll discuss in our opening. First, as a factual matter, claimants knew that their land was located within the boundaries of the Las Baulas Park, and that as a result, their property was subject to being expropriated. Second, I will show that claimants' claims fall outside of the tribunal's jurisdiction for 2 reasons. First, all of the alleged breaches about which claimants complain occurred before CAFTA entered into force. And second, claimants first acquired knowledge of the alleged breaches and their harmful effects more than 3 years before claimants submitted their notice of arbitration. And finally, my colleague, Ms. Howard-McCandles, will outline the many problems with claimants' assertions that Costa Rica has breached its CAFTA obligations and their request for damages. Please turn to slide 3. This slide provides a timeline of the key events in this dispute. Because the timing is important, I will explain in chronological order the events relevant to the dispute. And please note that all these events were before CAFTA entered into force and before the critical date for the statute of limitations. Please also note that all of the declarations of public interest issued so far for claimants' properties have been issued between 2005 and 2007. All decrees of expropriation issued so far with respect to claimants' properties have been issued between 2006 and 2008. And all the acts of dispossession issued so far with respect to claimants' properties have been issued in 2008. And you see that in the box at the bottom left-hand side of the slide. I'll come back to this. But now let me start with 1991. The first date on the timeline is 1991, and that's the date when the Las Baulas National Park was created. It was created by decree number 20518, which is on the record as Exhibit C1B. And the 1991 decree created, as part of the park, a 75-meter strip buffer zone, in addition to the 50 meters public zone that runs along the coast. The 50 meters public zone was declared an inalienable zone in 1977, meaning that no private party could own or develop land in that 50-meter zone. The law that created that 50-meter public area is in the record as Exhibit R001. The 91 decree added a 75-meter zone to create a park of 125 meters. The 1991 decree provided in the whereas section, in particular numbers 4 and 5 of that section, that, and I quote, "If tourist infrastructure were developed in those sites, serious disruptions shall be produced, and these would seriously affect the turtles. It is thus necessary to create a national park to perpetually protect the colony of leatherback turtles and other existing natural resources in the area." Close quote. In other words, the park was created to prevent any urban development that would affect the leatherback sea turtles that nested in the park. We believe counsel for claimants said this morning that the 1991 decree included a terrestrial component, so what I just said seems to be common ground between the parties. Now please turn to slide number 4. This is a map. The map on the slide is the Villarreal and Matapalo map sheet that is referenced in Article 1 of the 1991 decree to describe the boundaries of the park. Article 1 of the decree provides that, and I quote, "From a point located in the southern end of Playa Ventanas," which is identified in the map in front of you with a green dot, "the limit," I continue the quote, "the limit continues along an imaginary line parallel to the public zone and distant 75 meters, which means a total of 125 meters, 75 meters from it towards the southeast until the point of coordinates N255000 and east 335050. And that is identified in the map in front of you with a purple dot down to the south. So, as you can see on the map, the park covered a strip of land of 125 meters. There is no question that the coordinate I gave you, the purple dot, is inland. Clearly, the 125-meter strip is inland because it runs towards the southeast. I ask you to note, and I'll come back to this, I'll ask you to note that the 1995 law, the park law, references the exact same map in the same southern coordinates as the 1991 decree. But now back to the 1991 decree for a moment. In addition to the park, the 1991 decree created a protected zone in addition to the park. This is stated in Article 2 of the decree. According to Article 2 of the decree, quote, Playas Carbon y Ventanas, including a strip of land of 75 meters from the public zone, is declared a protected zone, close quote. The decree states that, quote, every residential development and of any other type made in this zone shall be approved by the Ministry of Natural Resources, Energy and Mines, close quote. What this means is that while Playa Ventanas was not at that point in time part of the park, it was declared a protected zone, and no development within that protected zone could occur without the express approval of the Ministry of Natural Resources, Energy and Mines. Playa Ventanas was subsequently included in the park by virtue of the 1995 Park Law. Article 4 of the 1991 decree provides that resources to purchase lands for the park are to be included in the budget, which means that the property inside the park would be expropriated. Please turn to slide 5. The entire 125-meter strip of land that formed the park and the protected zone was selected for a very particular reason: to protect the beaches where the leatherback sea turtles lay their eggs from urban invasion and development. Mr. Rotny Piedra, manager of the park since 1998, who will be testifying at this hearing, explained in his witness statements the abundant scientific evidence that shows that one of the biggest threats to the turtles and their reproduction is urban development in or near the nesting beaches. And thus the 125-meter strip of land is intended to protect the nesting and surrounding areas from, among other things, adverse impact from development. Now, 1995, the Costa Rican Congress passed a law that set out in greater detail the means to achieve the park's environmental objectives. Please turn to the next slide, which has an excerpt of Article 1 of the 1995 Park Law. Article 1 refers to the same map you already saw. And Article 1 of the Park Law provides the limits of the park, including the start and end point of the 125-meter strip of land. The north point now includes Playa Ventanas, which means that the protected zone of Playa Ventanas is now made part of the park. Council confirmed this morning, so it also seems common ground that Playa Ventanas was included in the park by virtue of the law in 1995. Please note that the south point is the same coordinates referenced in the 1991 decree, the exact same coordinates. And that point is inland. That is the end point of the park on the south. And so the 125-meter strip of land that runs along the coast of Playa Ventanas and Playa Grande is now part of the park, and the park includes a strip of land of 125 meters because the southernmost coordinate is the same as the 1991 law. And I emphasize again, the map, the 1991 decree and the 1995 law referred to is the same. And Article 2 of the 1995 law provides that the property within the park would be expropriated. The 1995 Park Law is Exhibit C1E. And as the respondent has explained in its written submissions, the Costa Rican Congress made an obvious mistake when describing the borders of the park. As you can see from the slide, in describing the area of the park, the law stated that 125 meters ran from the ordinary high tide offshore. Offshore, this is claimant's translation. We use the term seawards. I think it's common ground between the parties that it means towards the sea. The term in Spanish is aguas adentro. It is on this word, offshore or seaward or aguas adentro, that claimants base their entire case. According to claimants, this means that the park is extended to the sea and not inland. And therefore, they say none of claimants' property was inside the park. But when you look at this word in the context of the rest of the law and the map, there is no question that this was a mistake. First, as I just showed you, the southern end of coordinates provided in the law are on land. Thus, the only way the area described in the law ends at that specific southern coordinate is if the 125-meter strip runs inland and not seawards. And again, as I already said, the 1995 Park Law refers to the same map, which is referred to in the 1991 decree. Second, the Park Law would be internally inconsistent if the term seawards were not a mistake. Article 2 of the Park Law authorizes the expropriation of private land within the park, and I quote, "The private lots of land included in the delimitation will be susceptible of expropriation and will be considered part of the National Marine Park Las Baulas," close quote. If the park were only at sea, there would be no land that could be expropriated. Third, the main purpose of the park is to protect the nesting habitat of the turtles. If the park had not included a portion of land along the coast, the area where the turtles nest and its surrounding area would be left unprotected. The threat to the turtles is urban development. Urban development occurs on land. Fourth, as a matter of Costa Rican law, the Park Law could not have reduced the boundaries of the park created in 1991, unless there was a study that supported such a reduction. In this case, there was no such study. And we have provided the testimony of Ms. Gloria Solano, who explains this point of Costa Rican law. And we submit to you that that testimony is unrebutted. And thus, looking at the text and the purpose of the law, there is no doubt that the park included a 125-meter strip that runs along the coastline inland, not seawards. And that this was true was obvious to anyone who looked carefully at the Park Law. But there is much more. Contemporaneous actions and documents show that it was well understood at the time that the park ran 125 meters inland. And I'll go through some of those now. And for the rest, I refer to our written submissions. Please turn to slide number 7. So first, as is shown on this slide, on 7 May 2003, MINAE sent a letter to the municipality of Santa Cruz describing the park as including a 125-meter strip of land that runs along the coast. And I quote, "The park and the protected zone cover a strip that reaches inland 125 meters from the high tide on the aforementioned beaches," close quote. It also says that the 125-meter strip of land is in addition to the Cerro El Morro and the Isla Verde, land areas covered by the park. If MINAE, the relevant ministry of Costa Rica, understood that the park were seawards, it would have said so and would not have described the park as inland. This is on the record as Exhibit R100. I also want to refer to Exhibit C53, which was shown to you this morning, minutes of meetings of Costa Rican government officials. It was a slide, if you recall, where the text on the screen was not quite the text on the paper, but this doesn't matter. You can look at the exhibit itself. And what was not pointed out to you was the text. It was partially read, saying MINAE does not encourage the expansion of this national park. The sentence continues, up to 100 meters from the public zone, because there is a lack of financial resources to purchase lands. So the question was not whether the park extends 125 meters inland. The question discussed was whether the inland area should be extended to 1,000 meters. And that's what MINAE at the time did not support. But if you also look further down the text, there is a language that I'll quote from page 2 that says, in the private areas declared as a national park in 1991 and 1995, we would like to promote a voluntary conservation regime instead of resorting to the respective expropriations. So what MINAE was discussing is whether instead of the respective expropriations, they could find a way to impose a voluntary conservation regime. That didn't happen. But what this shows is that MINAE understood, and this is an internal government document, that the national park, both in 91 and in 95, provided for the expropriation of the private property within the 125 strip of land. Please turn to slide 8. The expropriations of private property inside the park started in November 2003. In a letter from the Ministry of Environment of Costa Rica, MINAE, to the National Environmental Technical Secretariat, referred to as SETENA, MINAE states that the issuance of the first declaration of public interest in November of 2003 marked the initiation of the expropriation proceedings inside the park. Again, if MINAE had understood that the park boundaries ran 125 meters seawards, it would not have needed to start any expropriation proceedings. This document is Exhibit C74. Next, please turn to slide 9. MINAE stamps on the land registry drawings dated 2002 certify that the properties located within the 125-meter strip of land are inside the park. This slide shows a stamp that was issued for lot B3. And this registry drawing is on the record as Exhibit C24A. The MINAE stamp is dated 2002, before any purchase was made by claimants. And it specifically states that the property is located inside the park. As you see, and I quote, based on the location that appears in the land registry drawing, the described property is located within the Las Baulas National Park. The date of the stamp is September 9, 2002. Claimant's counsel walked you through some of those. I represent to you, because it's in the record and in our submissions, that the same stamp from 2002 also appears in the registry drawings for the other B lots, B1, B5, B6, B7, and B8. Claimants started purchasing their properties in late 2003. Notwithstanding evidence like the land registry drawing I just showed you and that you see on the screen, demonstrating that the property is inside of the park, claimants deny that this is true. They deny that the land registry drawings show claimant's property was inside of the park. We'll get to that in a moment, but now please turn to the next slide. Slide number 10. It shows the land registry drawing for lot B3 dated this time 2005. The Minaya stamp also is dated 2005. This registry drawing clearly shows that lot B3 was inside of the park in 2005 as well. So you have evidence, the registry drawings of 2002 and 2005, and they show that this piece of property was part of the park in 2002 and in 2005. The claimant in relation to this property is Mr. Berkowitz, and he alleges that he disregarded the 2002 stamp, which dates before the purchase, because it only mentioned the 1991 decree. And he then argues that only in 2005 do Minaya stamps start referring to the 95 law. This argument was repeated this morning by counsel for claimants, saying that, well, you should disregard the 2002 stamp, saying the property is inside the park because it only refers to the 91 decree and not to the 95 law. Mr. President and members of the tribunal, whether or not the stamp in 2002 refers to the 95 law or the 91 decree is entirely irrelevant. The fact is that before claimants purchased their property, and in this particular case of the B lots, around the time Mr. Berkowitz was purchasing the property, before in 2002 and after in 2005, the land registry drawings told him the property was inside the park. Both the 2002 and the 2005 registry drawings showed that the property is inside of the park. Please turn to slide 11. Claimants Costa and Spence argue that the land registry drawings for their properties even certified that their properties were located outside of the park. What they fail to explain, however, is why the stamps provide that the properties are outside of the park. So let's take, for example, the land drawing for lot V38, which is on the record as Exhibit C7A. You have that on the screen, and as you can see, the stamp is dated 1993. Lot V38, as all of the Costa and Spence lots, is located in Playa Ventanas. As I just discussed, Playa Ventanas only became part of the park in 1995. And so any stamp predating 1995, predating the 1995 park law, would provide that Playa Ventanas and the lots in Playa Ventanas are outside of the park. But let's look at what happens after 1995. Please turn to slide 12. In contrast, land registry drawings for Playa Ventanas registered after 1995 do indicate that the property is located inside the park. Claimants have not submitted the post-95 registry drawing for the same lots, but they have submitted post-95 registry drawings for another lot located in Playa Ventanas. So we look, for example, to lot V59 owned by Spence International Investments, which is in Playa Ventanas. And you see on the slide the land registry drawing for this lot, Exhibit C12A. The stamp on this land registry is dated September 96, after the park law. And if you look at the stamp from Minae on the back of the page, it states that, quote, on the base of the location that appears on this map, the property described is located inside the Las Baulas National Park. A similar stamp is on the land registry drawings for lots V61A, V61B, and V61C, all dated 2006. And so the argument that the properties in Playa Ventanas are outside of the park because the registry drawings say so is simply wrong. After Playa Ventanas was incorporated into the park in 1995, the registry drawings bear a stamp showing that those properties are inside the park. According to Costa Rican law, landowners are responsible for updating the land registry drawings. This includes requesting Minae to certify whether the property is inside a national park. Had claimants updated the land registry drawings at the time of their purchases, Minae would have certified that the properties were inside of the park. Instead, some of the claimants prefer, at least for the purposes of this arbitration, to rely on drawings that had been registered as many as 10 years before they purchased their land. We find it hard to believe that they didn't obtain such registry drawings at the time of purchase, and we wonder why they weren't submitted if they were saying that the properties were outside of the park. And so, in spite of the fact that the registry drawings of 2002, before the purchases, and 2005 show that their properties are inside of the park, claimants insist. They allege that they could not have known that the property was located in the park because the 1995 park law provided that the park extended seawards. And as I already explained, that reference in the law was a mistake. And indeed, in 2004, the Procuraduría issued an opinion confirming the understanding of the law that the park area extended inland. The Procuraduría serves a function of a legal advisory body to the Costa Rican government, among its other functions. Its interpretations of law are authoritative and in some cases legally binding. In 2003, Minae requested from the Procuraduría an interpretation of the 1995 park law. In particular, Minae inquired about the meaning of the seaward language in Article 1. Minae's request is on the record as Exhibit R93. Please turn to slide 13. This is an excerpt from Procuraduría's response in February of 2004. The Procuraduría clarified that the only logical interpretation of the boundaries of the park was that Congress had mistakenly included the seawards reference and that the 125-meter strip reference in the law ran inland, Exhibit C1T. Claimants make much of the point that the first opinion of the Procuraduría was not binding on Minae for technical reasons. Nevertheless, this first opinion was significant. Claimants try to argue that because the opinion was not binding, it did not have any effect, and that is not true. It did have effect. It informed interested parties of what was, according to the Procuraduría, the proper interpretation of the law. The opinion was made public through the Costa Rican system of legal information on the website. And so if claimants had any doubts regarding the boundaries of the park, they could have consulted this opinion to clarify the matter. The 2004 Procuraduria opinion was not binding on Minae for a technical reason. Minae addressed the question to the Procuraduria, but did not attach a study supporting the question, which was required under Costa Rican law. In 2005, Minae corrected this technical defect and requested a new opinion from the Procuraduria, this time supporting the question with a study. The Procuraduria issued a new opinion on December 23, 2005, which was legally binding this time. This is Exhibit C1G. And this opinion essentially reproduced the 2004 opinion and logically confirmed it. The very last sentence of the 2005 opinion concludes that the park, and I quote, runs on land at a distance of 125 meters from the normal high tide, close quote. If you allow me to draw your attention again to the timeline we showed you earlier, which is now on slide 14. This timeline shows all the events through 2008. And I will discuss some of them in a moment. But the point here is that if claimants had any doubt whatsoever, if they knew nothing of any of these developments that you see on the timeline, if they had not obtained recent registry drawings at the time of the purchase, if they did not pay any attention to the Procuraduria opinions, then they would have certainly found out they were being expropriated when Minae initiated expropriation procedures for some of claimants' own properties in December of 2005, when it issued a declaration of public interest, for example, for all the B lots. In December of 2005, if they had no idea of anything else that was going on, they would have found out. Further, as early as 2005, the Constitutional Division of the Supreme Court declared that 1, the park includes a 125-meter strip of land, 2, private property had to be expropriated, and 3, the state should adopt any relevant actions to protect the environmentally fragile area of the park. In deciding cases on the constitutionality of the laws and regulations that impacted the park, the Supreme Court, in 2 different proceedings, reached the same interpretation of the 1995 park law as the Procuraduria. One decision was rendered in 2005, another in 2008. They're Exhibits C1V and C1H, respectively. Finally, in August 2005, SETENA issued resolution number 2238, 2005, Exhibit C1F, temporarily suspending the issuance of all environmental permits located inside the park. This suspension was a result of the Supreme Court's decision and subsequent orders by Minae. In 2008, the Supreme Court issued decision 2008-18529, in which it ordered SETENA to permanently suspend all environmental and building permits within the park area. Exhibit C1J. This Supreme Court decision resulted from a case brought by neighbors of the park who insisted that SETENA's issuance of environmental permits inside of the park was contrary to the state's constitutional obligation to protect the environment. And the Supreme Court so decided. In compliance with this decision, the state suspended all environmental permits inside the park and adopted several other measures to further protect the area of the park. They are listed in Exhibit R035 and Exhibit CZ1. And I want to emphasize the significance of the December 2008 decision of the Supreme Court, it ordered Setena to permanently suspend all environmental and public permits within the park in December of 2008. In sum, there is no basis for claimants to argue that the 125-meter strip ran seaward rather than inland. Any uncertainty regarding the park's boundaries that may have been caused by the mistaken use of the word seawards in the 1995 law was definitively resolved as early as February 2004 by the legal opinion of the Procuraduria, which was subsequently endorsed by the Supreme Court. And drawings in the record as early as 2002, before claimants purchased their properties, indicate with a stamp by Minai that the properties were inside of the park. And so what happened here was that claimant made a risky investment. They knew that the land they were purchasing was inside of the park and was subject to being expropriated. They thought perhaps it might not be, or they would sell it before it was expropriated. We don't know. What we know is that they took a calculated risk and lost. But Costa Rica should not have to pay for claimants' ill-fated gamble. The government maintained the park's boundaries and began to expropriate properties therein. And claimants should not be allowed now to blame Costa Rica because they underestimated Costa Rica's commitment to environmental conservation. Let me now turn to questions of jurisdiction. As I mentioned, everything about which claimants complain in these proceedings is time-barred for two independent reasons. First, CAFTA entered into force on January 1, 2009, and the alleged breaches about which claimants complain took place before that date. And second, CAFTA Article 1018 provides that, quote, no claim may be submitted to arbitration if more than 3 years have elapsed from the date on which the claim first acquired or should have first acquired knowledge of the breach alleged and knowledge that the claimant or enterprise has incurred loss or damage, close quote. Claimants filed their notice of arbitration on June 10, 2013, and therefore the key date for statute of limitations purposes is June 10, 2010. They knew or should have known about the breaches they allege before June 2010. So let me discuss those two grounds for lack of jurisdiction in turn. I will start with the argument that claimants' claims are time-barred under CAFTA because the alleged breaches occurred before CAFTA entered into force. The jurisdiction of this tribunal covers alleged breaches that occurred after CAFTA entered into force, that is after January 1, 2009. Article 28 of the Vienna Convention on the Law of Treaties establishes that unless a different intention appears from the treaty or is otherwise established, a treaty's provisions do not bind a party in relation to any act or fact which took place before the date of the entry into force of the treaty with respect to that party. In addition, Article 1013(3) of CAFTA provides, quote unquote, for greater certainty, that, quote, this chapter does not bind any party in relation to any act or fact that took place or any situation that ceased to exist before the date of entry into force of this agreement, close quote. In short, CAFTA does not apply retroactively. If a claim under CAFTA is based on measures that occurred before January 1, 2009, such measures cannot breach any provisions of CAFTA because there was no obligation at the time under CAFTA, and the claim, therefore, must fail. In this case, the measures about which claimants complain occurred before January 1, 2009. Therefore, Costa Rica is not in breach of its CAFTA obligations, cannot be found liable for any damages that may have resulted from those measures, and this tribunal lacks jurisdiction to hear claimants' claim regarding such measures. First, with respect to 9 of claimant's properties, and those are lots A40, SPG1, SPG2, B1, B3, B5, B6, B7, and B8. With respect to those 9 properties, claimants assert direct expropriation. With respect to timing, they point in their memorial on the merits to the act of dispossession as the moment when direct expropriation occurred. According to claimants, at that point in time, quote, the state takes possession of the land, thereby satisfying the customary requirement of a direct taking. This is claimant's memorial on the merits at paragraph 207. Well, the acts of dispossession for those 9 properties were issued on March 12, 13, and 14, 2008, and on December 9, 2008. All those dates are before CAFTA entered into force. Second, with respect to the remaining 17 properties, claimants assert indirect expropriation. Claimants allege that they lost the use and enjoyment of those properties as a result of the state's confirmation of the boundaries of the park and the state's restriction on development within the park. In particular, claimants allege that, quote, it is manifest that the only measure that could crystallize the creeping expropriation started in 2004 would be a final decision by MINAE to permanently terminate the permitting process and to revoke all existing permits. This event took place in 2010 after the CAFTA had come into force, close quote. This is from their reply on the merits at paragraph 294. But as a matter of fact, claimants are incorrect. This event took place in 2008, not 2010, and thus before CAFTA entered into force. The termination of the permitting process and the revocation of the permits occurred in December, actually on 16 December 2008, when, as I already discussed, the Costa Rican Supreme Court ordered the administration to permanently stop issuing environmental impact permits and revoked all existing environmental impact permits for properties located inside the park. So the indirect expropriation, the creeping expropriation, as they call it, crystallized in December of 2008. And this is also before CAFTA entered into force. Now, in their memorial, claimants complain that respondent has breached its obligations under CAFTA by not paying claimants prompt and adequate compensation and otherwise treating them unfairly and inequitably by the following allegedly arbitrary government actions. 1, the violations of the property by independent appraisers. 2, the judicial decisions on the violation of the property. And 3, the partial expropriation of the properties with respect to the portions of the properties that lie within the boundaries of the park. And 4, the temporary suspension of the expropriation process for properties not yet at the judicial stage in the proceedings. As a matter of fact, most of these acts occurred before CAFTA entered into force. But to the extent that they did not, they represent the lingering effects of completed acts. That is, the acts of the alleged direct and indirect expropriation. Those are the lingering effects of the direct and indirect expropriation, which on their own case was completed before CAFTA entered into force. None of these acts, which I refer to as the lingering effects, is a breach in and of itself of CAFTA's obligations. The foundation of claimants' complaints is the alleged expropriation of their properties, which was complete before CAFTA entered into force. Delayed payment, allegedly inadequate payment, allegedly stalled judicial procedures. These are purported harms stemming from a completed act of expropriation. The tribunal in Mondev, for example, agreed with this reasoning in its analysis of claims strikingly similar to this case. There, the tribunal found that it did not have jurisdiction over Mondev's expropriation claim because the claim concerned alleged breaches that took place before NAFTA entered into force. The tribunal held that if there were an expropriation of Mondev's rights in the investment, it was completed at the time that the alleged expropriation had definitive effect pre-NAFTA. Mondev may have experienced harm that continued into the time NAFTA entered into force, but the tribunal held that the mere fact that an act may continue to cause harm does not make that act of a continuing nature. Members of the tribunal, let us look carefully at what claimants are actually arguing. They say that both the direct and the indirect expropriation happened, crystallized, and completed before CAFTA entered into force. They say, however, that when CAFTA entered into force on January 1, 2009, CAFTA imposed on Costa Rica the obligation to pay prompt and adequate compensation for those expropriations that happened before. Council repeated this morning, the obligation that was breached was an obligation of expropriation in a manner consistent with CAFTA. But that obligation did not exist when the expropriations took place. When the expropriations took place, Costa Rica had no obligation to expropriate in a manner consistent with CAFTA because CAFTA did not apply retroactively. So claimants essentially argue that with the entry into force of CAFTA, the CAFTA parties became obligated to pay compensation for expropriations that occurred at an earlier point in time. Well, to put to you a blunt example, according to claimant's theory, if a Canadian investor owned a shoe factory in Costa Rica and that factory was expropriated 20, 30, or 50 years ago without compensation, for example, on January 1, 2009, an obligation under CAFTA to pay compensation kicks in. This cannot be. Before CAFTA entered into force, Costa Rica did not have, under CAFTA, an obligation to provide compensation for expropriation. In other words, prior to its entry into force, CAFTA could not have and did not prohibit uncompensated expropriation. At the time the alleged expropriations occurred, Costa Rica had no CAFTA obligation to claimants to pay prompt and adequate compensation or any compensation for that matter. And an obligation cannot arise under CAFTA to pay compensation with respect to an earlier expropriation, an expropriation that occurred when payment of compensation under CAFTA was not required. To the same extent that claimants' expropriation claims are time-barred by the entry into force of CAFTA, so too are claimants' allegations regarding whether such expropriations were conducted in accordance with CAFTA's standard of fair and equitable treatment. At the time claimant's property was expropriated, Costa Rica had no CAFTA obligation to carry out the expropriations in a fair and equitable manner, whatever that standard means, and we'll come back to that standard. In essence, claimants' other claims, other than the claims for direct and indirect expropriation, that is the claims for non-payment of prompt and adequate compensation, denial of fair and equitable treatment, denial of justice, etc., are nothing but the lingering effects of the alleged expropriation. That expropriation took place before NAFTA entered into force, and claimants now seek to portray the lingering effects of those expropriations as new breaches that took place after January 1, 2009. As I just discussed, similar arguments were addressed and dismissed by the tribunal in Mondev, and that analysis was endorsed by the recent Clayton Award. In Clayton, Canada, similarly to Costa Rica here, argued that the continuing effects of a measure do not transform it into a continuing measure. The Clayton Tribunal held, in light with the reasoning set out by Judge Schwebo in his expert opinion submitted in this case, and in line with the reasoning of the tribunal in Mondev, that although an act may have lingering effects that are felt after the completion of that act, those lingering effects do not transform a completed measure into a measure of continuing nature. In the words of the Clayton Tribunal, and I quote from paragraph 268, the tribunal's position that an act can be complete even if it has continuing ongoing effects is in line with the view of the tribunal in Mondev and further consistent with Article 14.1 of the International Commission's article on the responsibility of states for internationally wrongful acts, according to which the breach of an international obligation by an act of a state not having a continuing character occurs at the moment when the act is performed, even if its effects continue. And the Clayton Tribunal said further in paragraph 268, the investors refer in their submissions to the ongoing effects of imposing blasting conditions, the ongoing effects of requiring a comprehensive study of the investment, and the ongoing impact of the referral of the project to the JPR 380 issue specific to that case. And the tribunal concludes, those ongoing impacts, however, do not establish that there were ongoing acts. And this conclusion of the tribunal is quite relevant here. In sum, this tribunal has no jurisdiction because the alleged expropriations took place before CAFTA entered into force, and claimants complain simply of the lingering effect of those expropriations, some of which may have continued after January 1, 2009, but whether or not the lingering effects continue after CAFTA entered into force, this tribunal has no jurisdiction. Allow me now to move to the second independent ground for lack of jurisdiction, which is that claimants' claims are time-barred because claimants did not file their notice of arbitration within the 3-year statute of limitations provided under CAFTA. Article 1018 of CAFTA provides that an arbitral claim must be filed within, quote, 3 years from the date on which claimant first acquired or should have first acquired knowledge of the breach alleged under Article 1016.1 and knowledge that the claimant has incurred loss or damage, close quote. Claimants filed their notice of arbitration on June 10, 2013, and therefore the critical date regarding CAFTA statute of limitations is June 10, 2010, 3 years prior to the filing of the notice. It is absolutely clear from the record in this case that claimants first knew about the facts that about the acts that they alleged breached Costa Rica's treaty obligations and the harms resulting from those acts well before June 10, 2010. Claimants themselves have provided evidence that they first knew of the alleged breaches and that they incurred loss or damage as a result of those alleged breaches more than 3 years before they brought their claims to arbitration. In fact, claimants admit over and over again in their written submissions that they first knew about the alleged breaches, in particular expropriation, and the related harms well outside of CAFTA's statute of limitations. And I invite you to take a look at some of claimants' admissions regarding when they first acquired knowledge of the alleged breaches and the resulting loss. Please turn to slide 16. This is a list of quotes from claimants' notice of arbitration in their memorial. These are some of the dates claimants themselves identify in the notice of arbitration or the memorial on the merits. So let's look at them carefully. They say, at some point towards the end of 2005, all of the claimants eventually heard about Cetena's decision to temporarily suspend its environmental assessment procedure. And at some point in 2006, each claimant would have individually heard from a Cetena official that the Attorney General has issued some sort of an opinion apparently requiring them to treat their lots as being located within the park. The seriousness of their situation only dawned on claimants once the string of decisions rendered by the Constitutional Court in 2008 started to emerge. All this well outside of the statute of limitations. Next, they say it was not until 2005 for the Berkowitz group of claimants and 2007 for the Spence group of claimants that they realized the status quo ante might have changed. Again, well before 2010. Next, together, these two judicial decisions, they're talking about May 2008 and December 2008, constituted a final and binding prohibition of the development of all land within the eastern boundary of the park. Next, thus commencing with the Constitutional Court decision in May of 2008, directing Minaya to expropriate the land and concluding with the Constitutional Court's clarification of 27 March 2009, the respondent, and I emphasize, completed the creeping expropriation of the rest of the claimant's properties. So with the decision of May 2008 and the clarification of March 2009, on their case, Costa Rica completed the creeping expropriation of the rest of the properties. It was mentioned earlier that respondent has the burden to prove that they first knew of the acts they complain of before the statute of limitations kick in. With their own admissions, on their own case, we've made a prima facie case that they knew. The burden now would shift on them to disprove their own statements, because what they say here is clear. They argue Costa Rica completed the creeping expropriation before the statute of limitations kicked in. They could not have not known about that. And finally, on this slide, May 27, 2008, is the date used by their damages expert as the date on which he determines the value of the property, because of the requirement that the value of the property is determined on the eve of the expropriation. There is more. I invite you to turn to slide 17. It continues. By 2009, they say, respondent through various agencies, ministries, and courts had passed a series of resolutions and made a number of decisions that, without taking title to land, resulted in total deprivation of the claimant's rights to own and enjoy the property. By 2009, they say, there was a total deprivation of their rights to own and enjoy the property. They must convince you now that they didn't know about that. Total deprivation of the rights to own and enjoy the property. They cannot. This is their case. Next, second bullet. Claimants lost their investment 5 or more years ago. This is in their memorial filed in April 2014. So they claim they lost their investments before April 2009. Next, the respondent has maintained measures tantamount to expropriation of most of claimant's investment, which began with the decision of the Constitutional Court rendered on 23 May 2008 and crystallized with an order of the Minister of Minaya on 19 March 2010, in which he ordered his staff to terminate all pending environmental viability permit applications and never accepted another. So the measures tantamount to expropriation crystallized on 19 March 2010, again, before the critical date. Next, the order issued on 19 March 2010, they say, finally abolished any opportunity for the claimants to freely exercise their property rights. On their own case, the exercise of their property rights was finally abolished in March 2010. They have a very, very heavy burden to persuade you they didn't know about that in March of 2010. And finally, in terms of our examples, the answer, they say, to the question of when the composite impact of respondents' measure substantially deprived the claimants of their use and enjoyment of their property rights and interest in their investment was on or about 19 March 2010. The composite impact substantially deprived them of their property on or about 19 March 2010. All this, on their own case, was before June 10, 2010, the critical date for the statute of limitation purposes. And in fact, in claimant's memorial, they provide a summary list of all the respondents' acts about which claimants are complaining today. If you turn to slide 18, this is claimants' own summary of their case, their own summary of the measures or acts which they allege are a breach of CAFTA. I'm not going to read them all, but you will see that those acts begin in 1995 and end in March of 2010, all before the critical date of June 2010. This is their case, and to avoid their statute of limitation problem, they have to persuade you that they had no knowledge whatsoever about any of these measures until after June 2010. They cannot do that. There is ample evidence in the record that they acquired such a knowledge. And even if there weren't such an evidence, those are public measures, and claimants could have and should have known about them at the time they were adopted. Mr. President, members of the tribunal, we really could stop here because on their own case, they're out because of the statute of limitations in CAFTA. And we should have, because we believe that on that basis alone, those claims are frivolous. We'll return to that when we ask you for costs and fees. I would add that claimants also first knew or should have known of the alleged breaches of what they say is a breach of the Fair and Equitable Treatment Standard more than 3 years before they filed their notice of arbitration. They allege that respondent has treated them unfairly and inequitably in violation of CAFTA Article 10.5 by conspiring to deny claimants payment and by delaying the expropriation process that started many years ago. But these are the same harms that they claim as a result of the violation of the expropriation provision. And as I just discussed, all those measures occurred well before June 2010. And so the claims regarding fair and equitable treatment are also time-barred. So let me briefly discuss then what is it that they say in their attempt to seek to avoid the statute of limitations provision. Well, they have several arguments, and I'll discuss them briefly. First, they say the alleged breaches are continuing or composite in nature and thus continue into the statute of limitations period. Claimants assert, for example, that the failure to pay sufficient compensation or adequate compensation is a continuous breach. That's paragraph 71 of their rejoinder in jurisdiction. That assertion, Mr. President, members of the tribunal, does nothing to cure the lack of jurisdiction over those claims. The question is not whether the breaches are continuing or composite in nature and may continue beyond the critical date. The question is when claimants first knew or should have known of the alleged breach and harm. Allow me to use a very simple example to illustrate how untenable claimants' argument is. Let us assume that claimants were subjected to discriminatory treatment, make it discriminatory taxation. That started 20 years ago and continues to this day. Their claims would have been time-barred because they first acquired knowledge or should have acquired knowledge of that alleged discriminatory conduct and harm 20 years ago. The fact that this may be a continuous breach does nothing to remove the operation of the statute of limitations. Under CAFTA statute of limitations, it is enough that claimants knew about the alleged breach and harm more than 3 years before they filed for arbitration, and that results in a failure for this tribunal to accept jurisdiction. This issue has been addressed by NAFTA tribunals and resolved in favor of Costa Rica's position. According to the Grand River Tribunal, allowing investors to evade limitations periods by basing their claims on the most recent transgression, is the word used by the Grand River Tribunal, the most recent transgression in a series of similar and related actions by a respondent state would render the statute of limitations ineffective. This is the decision on jurisdiction at paragraph 81. And in the words of the Grand River Tribunal, where, quote, a series of similar and related actions by a respondent state, close quote, is at issue, an investor cannot evade the statute of limitations period by basing its claim on, quote, the most recent transgression in that series. Paragraph 81 of the decision on jurisdiction. To allow an investor to do so would, in the view of the Grand River Tribunal, quote, render the limitations provision ineffective. Close quote, again, paragraph 81. That argument was also addressed by the Clayton Tribunal. Claimants in that case alleged that certain acts and omissions of the Canadian government with respect to their investments were discriminatory, arbitrary, and unfair. And Canada, much like Costa Rica in this case, argued that the investors' claims were time-barred because of the alleged breaches occurred, and claimants knew about the harm they suffered as a result of those breaches more than 3 years before claimants filed their notice of arbitration. The claimants in Clayton disagreed, asserting that the actions which constituted the alleged breaches were continuing in nature and had continued into the time period within NAFTA's 3-year statute of limitations. The Clayton Tribunal ruled in favor of Canada. So the first argument, that this was a continuous act that may have started well before the statute of limitations but continued to the statute of limitations, is untenable. The second argument, claimants assert that they could not have known of the extent of the harm that they suffered as a result of the alleged breaches until the continuing measures had ended. And so, in this case, they say, they allegedly could not have known the extent of the harm until they received some compensation and could quantify the exact amount of the damages suffered. Because they didn't know what they would receive, so they didn't know what the delta would be between what they received and what they think they were entitled to. Several problems with that argument. Acquiring specific, detailed, and precise knowledge of the quantum of damages is not required. It is sufficient that a claimant knows, or should have known, that he or she has suffered harm as a result of the alleged breach. Knowing the extent of the loss or quantifying the exact amount of damages is not an event that triggers the statute of limitations period. And several NAFTA tribunals have made that point very explicitly. I'm referring to Mondev, Grand River, and Clayton. As the tribunal in Clayton stated in paragraph 275, quote, the tribunal agrees with the reasoning of its predecessors on this point. The plain language of Article 1116(2) does not require full or precise knowledge of loss or damage. It might be that some qualification can be read into the plain language, such as a requirement that the loss be material. To require a reasonably specific knowledge of the amount of loss would, however, involve reading into Article 1116(2) a requirement that might prolong greatly the inception of the 3-year period and add a whole new dimension of uncertainty to the time limit issue. It would have to be determined in each case not only whether there is actual or constructive knowledge of loss or damages, but whether the investor has knowledge that is sufficiently actual or concrete. The Grand River Tribunal reached the same conclusion. According to that tribunal, and I quote from paragraph 77 of the decision on jurisdiction, damages or injury may be incurred even though the amount or extent may not become known until some future time, close quote. And the same tribunal, one paragraph later, in paragraph 78, said, in this respect, the tribunal's views parallel those of the NAFTA tribunal in Mondev. The claimant there also faced difficulties arising from the time limitations of Article 1116(2) and 1117(2). The claimant sought to surmount these with the argument that it could have certain knowledge that it had incurred injury from the events prior to the limitations period only after it knew the outcome of subsequent litigation that stood to quantify the extent of loss was known. The tribunal did not agree, finding that a claimant may know that it has suffered loss or damage even if the extent of quantification of the loss or damage is still unclear. Close quote. Thus, claimants' lack of full knowledge of the extent of their damages does not reset or toll the statute of limitations period. And Mr. President, members of the tribunal, even today, claimants do not know the exact amount of their damages. In fact, they are still seeking to quote-unquote update their damages, and that attempt shows that they will not know the amount of damages, the exact amount of damages, until all judicial proceedings in Costa Rica have been completed. Now, claimants go as far as asserting that, quote, knowledge of both loss and breach is not possible until the system fails to provide a final compensation result, close quote. That's their rejoinder on jurisdiction, paragraph 108. So they admit that it is not possible to know the exact quantum of damages until the Costa Rican system fails to provide a final compensation result. Obviously, under this theory, the statute of limitations under CAFTA would be rendered meaningless. Let me also point out, however, that claimants' own theory, and that's their theory, not our theory as they refer to this morning, under claimants' own theory, their claims are premature. They either have a claim today of a specific amount of damages, or they will not know the quantum of damages, or in fact whether they are damaged, until the Costa Rican system fails to provide a final compensation result. If they don't know yet the extent of the damage, or whether they would be harmed, or whether they will be paid in full, there would be no breach, and they won't know whether there is a breach until all domestic proceedings in Costa Rica are completed, which obviously raises the issue. If that is true, why are we here, and why claimants don't wait for all domestic proceedings to render a final result? They cannot have their cake and eat it too. If claimants first acquire knowledge of the breach and the harm when the domestic proceedings provide a final compensation result, there is no claim ripe for adjudication yet. If there is a claim ripe for adjudication here, they must know that they are harmed. Their third argument: to avoid the devastating effect of the statute of limitations, they have shifted their case dramatically in an attempt to show that their claims are based on events after June 2010. Claimants' case, as set forth in their notice of arbitration and their memorial on the merits, as we just demonstrated, clearly shows their knowledge of the alleged harms caused by the state, and that knowledge goes back well before June 2010. What I showed you on the slides is in stark contrast to statements that they make now in their rejoinder on jurisdiction, where, in essence, they try to add new measures to their case in an attempt to show that something happened after June 2010. Please turn to slide 19. This slide compares statements made in the notice of arbitration, the memorial on the merits, with statements made in the rejoinder on jurisdiction. I'm not going to go through the statements on the left-hand side of the slide. We talked about them already. But let us see what they now say in their rejoinder on jurisdiction. They allege that other measures that have occurred later in time constitute the basis of their claim. Let's see what they say. They say in May 2010, there was a new legislation, but it failed to reach the floor for a vote before new administration and new Congress were installed. And it is then, when this new legislation failed, that they started considering their CAFTA options within 6 months. Well, first, May 2010 is still before the critical June 2010 date. But second, this is not a measure. The fact that there was a bill that was proposed and that it didn't reach the plenary or was not adopted and didn't reach a vote is not a measure they can complain of. So this says nothing about their argument that they should avoid the statute of limitations. Next, they say again, in May 2010, Laura Chinchilla was elected into the office of the president and distanced herself from the bill. Again, May 2010, 1 point. Second point, the fact that there was a new president who didn't support the bill is not an act, a measure they can complain of. So it does nothing to help them in terms of their statute of limitations problem. Next, claimants submit that the respondent's position on the proposed park only solidified in June 2010, following the installation of President Chinchilla and her administration. We don't know what solidified means, but they don't talk here about a measure. And the last bullet point that you see on the slide is similar. After President Chinchilla took office, they say Costa Rica took a hard line, assuring claimants that their lots will be expropriated. Well, the line that their lots would be expropriated, as we demonstrated, had been taken many, many years prior to that point when President Chinchilla took office. None of this talks about a measure adopted after June 2010. But of course, it is not surprising that claimants claim in their rejoinder on jurisdiction that they base their claims now on new allegations compared to their notice of arbitration in the memorial. They do need to point to something that would anchor their claims to the time after CAFTA came into force and within 3 years of the statute of limitations. Interestingly, only when claimants were faced with the possibility that their claims could be time-barred did they assert that the actual date when the acts about which they complained crystallized later than what they initially said was the March 2010 date. This attempt, of course, as I just showed you, is not effective. And moreover, those newly invented allegations have no merit whatsoever. Again, whether respondents' position with respect to the park hardened or softened in May, June 2010 is irrelevant. The relevant measures were adopted well before that. Whether claimants hoped that a new bill would be adopted that would amend or repeal the expropriation statute does not change the fact that there was a measure on the books that allegedly expropriated their investments. And even if claimants decided to wait with the CAFTA claim to see if they can resolve their dispute otherwise by lobbying the government or by seeking the adoption of a new law, that has absolutely no effect on the statute of limitations. It was a strategy, if that was a strategy, it was a strategy they pursued at their own risk. Interestingly, in paragraph 310 of their reply, they say, that's their reply on the merits in the counter-moral jurisdiction, they say, I quote, that they shouldn't be denied relief on the basis of 3 months' worth of extra patience. They said, we just had to wait 3 more months to see if this would be resolved. We should not now be bumped out because of the statute of limitations. Even if there was any merit to this assertion that it was only 3 months they had to wait and be patient because the issue was just about to be resolved, and we don't see any merit to this claim. But even if that were the case, my only answer is a story that I can tell you about a client who was visiting from New York and who texted me to say, I was only 5 minutes late and the train had departed Penn Station. It doesn't matter whether it's 3 months, 3 weeks, or 3 days. They were out. They are out because the statute of limitation kicks in June of 2010. And whether they should not, whether it's unfair because of 3 months or 3 years or 3 days is irrelevant. This is not a sliding slope. It's a fixed date. And finally, claimants go as far as to allege that the government of Costa Rica has breached its CAFTA obligations through new delay measures that it discovered as a result of reading about them in Costa Rica's reply on jurisdiction and rejoinder on the merits. Claimants allege that the Ministry of Environment's suspension of the administrative phases of the expropriation in order to implement the recommendations of the Procuraduría is a new breaching measure because it denies claimants justice. Well, if claimants didn't know about this measure at the time they filed a notice of arbitration, they say they didn't, they cannot raise a new claim now in this arbitration. They would need to submit a new notice of arbitration, a new proceeding about a new measure they complain of. They cannot simply tack on every government action, they cannot simply tack on every government action that has taken place since CAFTA entered into force and within the 3-year statute of limitations so that they claim their claims are not time-barred. And again, I refer back to the Grand River Tribunal's conclusion. Allowing investors to evade statute of limitation period by basing their claims on the most recent transgression in a series of similar and related actions by a respondent state would render the statute of limitations ineffective. And so no matter how claimants may try to recast their claims, they're outside of this tribunal's jurisdiction. The fundamental breach about which claimants complain is the expropriation of their properties. The acts that allegedly affected that expropriation can have effects that continue beyond the time when the acts themselves were completed, but that does not mean that those effects are separate breaches or that the acts themselves are continuing or composite in nature, even if claimants try to recast them in an attempt to squeeze them into the tribunal's jurisdiction. Mr. President, members of the tribunal, I will take one more minute before I ask for a break and ask my colleague, Jennifer Howarth-McCandles, to continue with merits and damages. But I need this minute because I must address claimants' accusations of improper conduct by a respondent in this proceeding. In paragraph 8, and elsewhere in the rejoinder on jurisdiction, claimants assert that introducing the expert report by Judge Schwebo is, quote, nothing short of improper, close quote. They base this accusation on 2 grounds. First, they say, quote, an expert opinion on international law is unnecessary in a dispute that is governed exclusively by CAFTA and applicable international law, close quote. This argument is as nonsensical as it sounds. They say an opinion on international law is unnecessary where the dispute is governed by international law. We disagree. Second, they say, quote, any expert legal opinion that purports to provide the tribunal with the answer to the decision its members have been appointed to make is unnecessary and inappropriate. Well, this is what expert opinions do. They seek to address and provide an answer to a question or questions that are before the tribunal to decide. There is nothing inappropriate in presenting an expert opinion on international law, providing answers by the expert to questions that are before this tribunal. And we regret that claimants have leveled such a serious accusation, and we are compelled to place on the record our objection. With that, Mr. President, perhaps we should take a break.
Thank you very much. Thank you very much. I think that is an appropriate moment to take a break. So if we reconvene, let's say at 5:02 on that clock. Thank you very much. I'm conscious of the fact that maybe English sensitivities of how one tells the time may cause some confusion. Yes, I mean 5 minutes to 4 o'clock if we could reconvene.